Hey everyone, I'm Bianca Jordan, an immigration lawyer at Brazen Legal, where I help immigrants get green cards every day. If you'd like to discuss your immigration case with us, you can call, text, or WhatsApp us at 508 942 7497. Today's quick video is to dive a little bit deeper into yesterday's Supreme Court decision in Sanchez v. Mayorkas. I've been seeing a lot of people freaking out and worried, saying that the Supreme Court just took away people's ability to get green cards if they got TPS, and that is not true. So I want to take some time to explain what really happened and just to assure people that people with TPS will still be able to apply for green cards. So again, there are two ways in order to get a green card. One of the ways is to go through consular processing, which means that you're getting your green card outside of the United States. The other process to get a green card is adjustment of status, and that means that you're getting your green card in the United States. The Supreme Court case dealt with people who are trying to get their green cards in the United States. In order to get your green card in the United States, you have to meet certain requirements. First, you have to have been inspected and admitted, or inspected and paroled into the United States. That basically means that you have to have come to the United States legally. Next, you've got to be an immediate relative. And for immigration purposes, an immediate relative means that you are the spouse, unmarried child under the age of 21, or parent of a U.S. citizen. So siblings don't count as immediate relatives for immigration purposes. If you're married to a green card holder, you're not considered an immediate relative. But again, this is for immigration purposes. The third requirement in order to get your green card in the United States is that you have to be admissible, which basically means that you don't have any negatives about yourself or your case that would cause immigration to want to keep you out. For example, you don't have any criminal histories or major criminal activity that would cause the government to not want to issue you a visa or a green card. So back to the requirements. The first one, you have to come here legally in order to adjust your status. You have to have an admission, which again means that you came here legally. So the issue in the case is that there are a lot of people who came to the United States undocumented, and then they were able to get temporary protected status. And one of the benefits of getting temporary protected status is that you are able to apply for something called advance parole, which is a travel document that allows you to leave the United States and safely come back to the United States. And when you come back to the United States, that entry on advance parole counts as a lawful entry, as if you were paroled into the United States. So therefore, you're meeting that first requirement of being able to get the green card in the US. You have an admission. You are inspected at a border and you are admitted or paroled into the United States. But there are some people who came to the country undocumented and they weren't able to travel on advance parole even though they got TPS. And that's the issue that the Supreme Court had to decide yesterday. And for those people, again, people that maybe came here undocumented and then they were able to get TPS, but they weren't able to travel back and forth to the US to have that lawful entry. There are some states in the United States that allowed those people to adjust their status because they allowed those people to count temporary protected status as an admission, meaning that even though these people came here undocumented, because they had TPS, they were able to adjust their status because they were treating TPS as if it were an admission. We had some states in the United States that did not agree with this. So you had a split. You had a variety of states where people who came here undocumented were able to get TPS and they were treated as if they came here legally, as if they had a lawful admission. And then you have a whole bunch of states that say no, TPS does not count as an admission. So whenever you have something like that that is inconsistent, then oftentimes it'll go up to the Supreme Court, and the Supreme Court has to make the decision as to what to do. So that's what the United States had to decide. The United States Supreme Court had to decide whether having temporary protected status counts as an admission that would let you adjust your status, aka get your green card in the United States, despite the fact that the law says you need a lawful admission to come here. So, in other words, the Supreme Court had to decide, if you come here undocumented and get TPS, can you still adjust your status? Can we treat that TPS as if you have legal status to adjust your status in the US? The Supreme Court decided no. And the Supreme Court decision, while disappointing, was not really surprising because, again, under immigration law, the section that deals with adjusting your status through a family member is 245A, and that part of the immigration law says that the first requirement is that you have to have been inspected and admitted or paroled into the United States. So if you come here undocumented, you cannot apply for your green card here, even if you meet the other requirements, even if you are considered an immediate relative, even if you're considered admissible for other reasons. Because you did not come here legally, you cannot adjust your status, and instead you have to go through consular processing. So that is what people in this situation are going to have to do. If they came here undocumented and then they get TPS and they are an immediate relative, they're not going to be able to get their green card here. They're going to have to go through consular processing. So it's very important to understand that the Supreme Court did not take away your ability to get a green card at all if you have TPS. Instead, the Supreme Court reinforced that in order to adjust your status, you need a lawful entry, and TPS does not count as that lawful entry. This does not change people who came here undocumented, got TPS, and were able to travel on advanced parole. Those people are still able to adjust their status as long as they left and came back to the United States before August 20th of 2020. It's also important to understand that yesterday's ruling at the Supreme Court does not impact people with DACA who maybe are wanting to travel on advanced parole. If you have DACA, you can still travel on advanced parole, and when you return to the United States with advanced parole, that is a new lawful entry, so you would be able to adjust your status as long as you meet the other requirements. But for people who have temporary protected status, if you come here undocumented and you got TPS and traveled on advanced parole before August 20th, 2020, you're still able to adjust your status or get your green card in the US. If you came here undocumented, got TPS, and did not travel on advanced parole before August 20th, 2020, you'll have to go through consular processing. And before you apply for a green card through consular processing, if this is your situation, I highly encourage you to speak with an immigration attorney. You can call our law firm. We'd be happy to help you, because depending on how much time you are in the United States undocumented before you have to leave to go get your green card overseas, you might need an immigration waiver, and not everyone who qualifies gets one, and the processing times right now are taking a little bit of time. I hope you found this video helpful. I really just wanted to come on and just reassure people that if you have TPS, you can still get a green card. The Supreme Court did not say that people with TPS can no longer get green cards. They simply said that if you have TPS, especially for people that came here undocumented before they got TPS, the Supreme Court simply said that they're not going to treat temporary protected status as if it were an admission that would allow you to adjust your status under the immigration laws regarding adjustment of status. They did not say you could not get a green card. You just won't be able to adjust, but you can still get a green card through consular processing. Again, I hope you found this helpful. Please visit brazenlegal.com to learn more about me, my law firm, and how I can help you get a green card. If you're not already, please follow me on Instagram, and please subscribe to this YouTube channel so you don't miss the next video. Thanks for watching.